Hello everyone, thank you for joining us today. Our presentation is focused on different case studies on contract law and tort law. Over the next 15 minutes, we will be sharing insights and information on various cases with relevant citation of previous case studies. I am Vikas and I'm joined today by Davinder and Shai. Without further ado, I will get started with the presentation. First one, Karen versus T. Contracts are essential to any legal system as they create legally binding obligations between parties. The law recognizes family agreements, but there is a presumption against an intention to create legal relations. Examining the case of Karen and her brother Dave and whether they had a legal agreement that gave Karen the right to Dave's property upon his passing in exchange for traveling to Sydney to take care of him. Dave offered Karen all his possession in exchange for her relocating to Sydney to take care of him. Karen agreed to the pledge, quit her job, sold her home, and moved to Sydney to keep her end of the bargain. However, Dave broke their agreement by having sold his property and leaving Karen alone. The court may infer that Dave and Karen intended to establish a legal connection when they established their agreement. Karen's decision to leave her work and home to take care of her brother was motivated by Dave's pledge, which qualifies as consideration. However, the court might also want Dave's ill condition and the pressure he was under when he took the pledge. In Balfour versus Balfour case, the court determined that there was no legal binding contract between a husband and a wife because there was no intention to establish legal ties. The agreement was viewed by the court as a domestic contract between the parties. The decision established that the rule family agreements have a presumption against an intention to establish legal connections. The existence of a legally binding contract between Dave and Karen is debatable considering the available evidence. Even if there existed a contract, the court might conclude that neither Dave nor the other party intended to enter a legal relationship. Therefore, this case can be considered voidable. The next is Chatham Bank versus elderly couple. Chatham Bank's mortgage rights are being questioned considering the attempt to enforce their mortgage rights against a Lebanese couple who had little formal education and a poor understanding of English. The couple agreed to mortgage their home as security for the debt suffered by their son's business. The bank is now attempting to enforce its rights under the mortgage after Ali's company fell into liquidation. The bank has the right to enforce its rights under the mortgage agreement in cases where a mortgage is issued as security for a debt. However, the contract could be voided if it can be proved that the bank acted unethically or took advantage of the couple's vulnerabilities. In the Commercial Bank of Australia versus Amadio case, the High Court of Australia recognized the doctrine of unconscionability in mortgage contracts. In the instance, an elderly couple with little English knowledge agreed to a mortgage over their house as collateral for the debts owned by their son's business. Although the bank was aware of the couple's vulnerability, it did nothing to ensure that they were aware of the implication of mortgage. The mortgage was thrown out of the court after finding that the deal was unfair. Similarly, in the current situation, the Lebanese couple had little formal education and a poor understanding of English. The son Ali, who had financial issues, misled them into believing that their son's business was solid. Considering the Commercial Bank of Australia versus Amadio case, it might be argued that Chatham Bank may have violated morality by exploiting the elderly couple's vulnerability. The bank was aware of the lack of understanding and did not take sufficient steps to ensure that they did not take the sufficient steps to ensure that they were aware of the implication of the mortgage. Therefore, the mortgage contract may be ruled out for being unfair. The next one is loss incurred due to delayed supply. The scenario revolves around Brad, Jane, and Angie, who entered into a legal agreement for the quick delivery and installation of firewood oven. However, Angie failed to deliver and install the oven on time, resulting in Brad and Jane losing a significant amount of profit. The question at hand is whether Brad and Jane can sue Angie for the loss of profit. To establish a claim for damages, Brad and Jane must demonstrate that Angie owed them a duty of care which was breached and then failed the duty resulted in their loss. In this situation, the legal agreement between Brad, Jane, and Angie established a duty of care on Angie's part to deliver and install the oven on time. However, Angie breached the duty by failing to deliver the oven by agreed upon deadline. The Hadley versus Baxendale case serves as an essential legal precedent in this situation. In the Hadley case, the plaintiff and defendant entered a contract for the delivery of the damaged mill shaft to the manufacturer for repair. Due to the defendant's delayed delivery of the shaft, the plaintiff suffered financial losses during that time. The court ruled that the defendant was responsible for the plaintiff's lost earnings since it was an obvious result of the contract's breach. Another relevant case could be Jarvis versus Swan Stores Limited. In this case, the plaintiff booked a package holiday with the defendant's travel company. The defendant failed to provide adequate accommodation, causing the claimant to suffer personal injuries and financial loss. The court held that the defendant was liable for breach of contract and awarded damages for the personal injuries and financial loss suffered by the plaintiff. Based on the above facts and legal applications, Brad didn't have a valid claim against NG for their loss of profit. Next will be explained by Davinder.
Hi, now I'm going to start my presentation. Um, my name is Devinder Kaur Sani. Um, I'm going to start my presentation. My question is Deliver versus Bus Tour Company. Business providing services have a primary responsibility to ensure the safety and well-being of their customers. In the case of a bus tour company, they owe a duty of care to passengers to take necessary precautions to protect their safety. If a passenger is injured due to the company's failure to uphold this responsibility, they may have grounds to sue for damages. Gulliver was injured in a bus accident while on a tour and may have the right to sue the tour company for the full cost of his tour. As a customer on one of their tours, the company ought to deliver a duty of care which may have been breached by the accident. Accidentally, because of his injury, Gulliver did not receive the full value of his tour and could argue that the company is liable for damages. The case of Dunga v. Stevens, UKHL 100 is relevant as it established the neighbor principle, which obliges individuals to take reasonable care to avoid harming others nearby who could be affected. Similarly, Gulliver's case highlights the duty of care owed by the bus tour company to him as a passenger and the potential liability for damages resulting from a breach. In conclusion, businesses must ensure the safety of their customers, and failure to do so may result in liability for damages. Gulliver may have grounds to sue the bus tour company for the full cost of his tour due to their breach of duty of care and resulting injury. This case serves as a reminder to businesses to uphold their responsibilities to their customers and take necessary precautions to ensure their safety. The next question is uh, Biggles Wells Amelia. In this scenario, Biggles loaned Amelia $1,120 and she agreed to sell her Apple notebook and give him the money she made from it. Amelia sold the notebook for $900 and gave the money to Biggles, who promised not to take legal action against her for any remaining debt. However, Biggles later demanded the remaining $220 from Amelia despite having previously agreed to accept the sale proceeds as full payment for the debt. According to the common law's interpretation of accord and satisfaction, a creditor is prohibited from pursuing further collection attempts if they agree to settle a debt for less than what is owed, and the debtor accepts the lower sum as a complete payment of the debt. Acceptance of the lesser sum is required only if it fully discharges the debt. This rule was established in Penal's case. In this instance, Biggles had already agreed to accept the sale proceeds as full payment for the debt, and Amelia had fulfilled her obligations by selling her notebook and giving him the $900 she earned from it. Therefore, Biggles is not legally authorized to demand the remaining $220. The debt has been cancelled because Amelia has complied with her commitments under the loan agreement. In summary, under the common laws interpretation of accord and satisfaction, Biggles is not allowed to break his word and demand the remaining $220 after previously agreeing to accept the sale proceeds as full payment for the debt. The debt has been discharged and Amelia is no longer obligated to pay any remaining balance. Now, Sheikh Rafia will present the question. Thank you.
Hi everyone, my name is Sheikh Rafia Begum. Thank you, Vikas and Davinder. Now I'm going to discuss about the tort law. I'm going to discuss the meaning of tort law. Tort law is nothing but a legal wrong which one person commits on another person. Some examples of tort law is commonly known as assault, battery, or the conversation of personal properties and intentional inflictions of emotional distress. So there is the three issues here. Now we are going to discuss on them. The first issue is Jean versus EEFC supermarket. Here the Jean is the frequent shopper for the East and Four Corner supermarket. During his visit, accidentally, this Jean slipped on an aisle, which caused her to break her ankle, which has happened accidentally. Though the store manager accepted that there has been an issue, spillage in the green sections. However, they are unsure if they will be liable for the damage of $1.3 millions to Miss Jeans. So, according to the rule, by taking reasonable precautions in all respects to prevent accidents, the law of negligence as well as the Civil Liability Act 2022, if the risk doesn't pose significant damage, the defendant will be liable for damages. Also, defendant cannot be held liable for negligence unless they own the plaintiff duty of care and the damage is not caused by the plaintiff negligence. Here, the application of law, according to the negligence law, the supermarket must take care of their duty towards Jean due to because there is a connection between the seller and customer. The supermarkets need to check every 15 minutes if what is the floor condition there, because there is normally the customer is come and go, so they have to be take care of that also. The Civil Liability Act 2002 states that there has been many breaches of duty of care, including a forcible risk liability to cause injury if the severity of the injury is not considered, if they're not considered, so that Jean broke her ankle. Here to overall to conclude, this scenario analysis that the market breached the duty of care while shopping at the store. Jean inadvertently fell onto the ground, fell to the ground around her and broke her ankle. However, to mitigate liability in cases of contributory negligence, the store must admit and liability in defense. Likewise, it is also Jean responsibility because it is partially blamed to Jean also. He have to check around. He have to always check around the surroundings because it's safe or not. And the second issue is here. Now the second issue is Johnny versus Anne. Johnny has had Anne to clean the pool. While cleaning the pool, his car was damaged because of a hailstorm. It's not Johnny's mistake, but the owner of the car, Anne, was he was breached. He was he was cut, telling that John has making the mistake, and because of his mistake, the car has broken. But it's not John's mistake. According to John has breached his duty of care and is liable to make amends to Anne on damages of $25,000. So, according to the rule, by taking reasonable precautions in all respects to prevent accidents, under Civil Liability Act 2022, Section 5L exempts defendants from liability for injuries caused by hazardous recreational activities. It is not John's it is not John's a mistake to he is not knowingly he doesn't do that. It is just an recreational activity. Leisure activity that may pose serious physical harm fall under hazardous leisure activities too. For application of law in this case, Anne has made a complaint on Johnny for negligence for his damage to the car, but which caused a loss of $5,000. However, his car damage is not the fault of Johnny, as he was hired to only clean his pool. Therefore, Anne has to show the valuable proof that the John has did this action, but it wasn't his fault, as the hailstorm caused it. According to the civil liability legislation 2022, a person is not deemed negligent if they have not failed to take reasonable measures against the danger of injury, unless they were aware of the risk. So here, to conclude, Johnny is not liable for the breach of duty of care, as is only hired Anne to clean the pool. To make an effective approach to the case, the defendant and plaintiff had to take advice. They both have to take the advice from the professional to solve the conflict and understand what is the situation that has happened there. And the third issue is it is about the Polly versus Sam. One evening, one of the Polly's friends, Sam, offered her giving a ride to her home. It was found that Sam had a driving license only for 2 weeks. On way home, Sam put the driving speed limit, but could not put the car on the track due to heavy rainfall. So Polly wanted to slow down the car limit and asked Sam to do so. Due to uncontrolled, Sam hit the telephone pole, which expect the loss is $200,000. Considering the accident, the main issue of this case is whether Polly will succeed if she files a negligence suit against Sam. And in Sam's case, in the same Sam case, whether he can defend himself or not. So the rule is, in this case, the tort of negligence become an issue. By taking reasonable precautions in all respects to prevent accidents, the subsequent events leads to significant contribution. Also, these sections cover the subsequent actions that would have prevented the risk of harm, which do not create or affect liability for the risk and do not constitute an admissions of liability for the risk. Application of law here. Consequently, the Sam and Polly were injured due to Sam driving. It's not a Sam mistake too, because it's a heavy rainfall and Sam cannot control himself. Regarding the applicable law, Sam and Polly were unaware of whose fault that was and presented conflicting evidence. Despite of this, police sue against Sam for the damage. Sam can take approach of defend himself in the case. It can be said that the chain of causality has been broken. Against this background, the term significant contribution is appropriate. To conclude this case overall, Sam will be liable to defend against Polly's case, as Polly cannot anticipate every driver's decisions. Despite a duty of care being owned, there is no breach of the duty. Due to heavy rainfall, it could not look properly, which caused the accident. So it is not proof that it is a Sam mistake that he has knowingly have did the accident. Thank you. So this is the end of our presentations. This is